The war on the Voting Rights Act continues, and it's going to be in the hands of the uber-conservative 6 of the United States Supreme Court later on this year to decide the fate of Section 2 of the Voting Rights Act, the section of the VRA that says that minorities should have the opportunity to be able to elect a candidate of their choice. And Section 2 speaks directly to the redistricting efforts, the gerrymandering efforts that are happening right now in Texas, Florida, and as we may see in places like Indiana and Missouri. And so I want to bring to your attention some very interesting maneuvering that's just happened at the Supreme Court that has flown under the media's radar, but is so important for us to be paying attention to, because we already know that the Voting Rights Act was destroyed in a very significant way through the Shelby decision. And so I want to kind of get us recalibrated on what's happening so that you know and you can share this information. So let's start with a case called Robinson versus Ardoin, Ardoin. That was a lawsuit that was brought by Black voters. And basically, those Black voters were suing the state of Louisiana, and they argued that Section 2 of the Voting Rights Act required that a second congressional district be drawn, so that Black voters could have an opportunity to elect a candidate of their choice. Section 2 of the VRA has that same kind of underlying idea that when you have a minority voting bloc or a group of people that are a minority, people of color, courts have said that Section 2 requires that new districts be drawn when there is a large and cohesive minority population concentrated in a specific area. And when the minority has difficulty electing its preferred candidates, then Section 2 of the VRA is invoked, and courts have used that to justify having congressional districts drawn in a way to benefit and to protect those minority voters. So in Ardoin, these Black voters sued, and they ended up getting an additional congressional district drawn. Because in Louisiana, after the 2020 census, that state's legislature only gave one congressional district for Black voters. So these Black voters sue in Robinson versus Ardoin, and the court says you get a second congressional district. So that's kind of the lay of the land right now. So the case that the United States Supreme Court heard oral arguments on in March of this year was called the following: Louisiana versus Calais, Callais. So Louisiana versus Calais is a lawsuit that was brought. And in that lawsuit, a brand new group of voters are saying that that second district that was drawn, that second congressional district that was drawn, that was to allow for the Black population to elect a candidate of their choice, that second district violated the United States Constitution's Equal Protection Clause because it was on its face a racial gerrymander. I know the irony abounds. In 1993, the United States Supreme Court said that a racial gerrymander occurs when race is the central factor in drawing district lines, and the state has no compelling interest in drawing those lines. So oral arguments happened in March of this year, and during those oral arguments, it is made clear that the Section 2 of the Voting Rights Act allows for districts to be drawn in the way that was done in Louisiana. But these voters that were suing in the Calais case said, no, you can't do that. Because it's a racial gerrymander, you can't do that. Instead of deciding the case at the end of June, just a couple of months ago, as the court normally does, the court instead punted making a decision until later this year. But that is unusual. And that usually doesn't happen. And in fact, according to Richard Hasen, Hasen, in a piece that he wrote for Slate, the court set up Calais for re-argument. He notes that it's rare, but it's not unheard of. And he cites back in 2010, SCOTUS actually took the Citizens United case and set it up for re-argument the following September. But then we all know what happened as a result of that, courtesy of Citizens United. So instead of reaching a decision after oral arguments in March of this year in this Calais case, the Supreme Court set it up for re-argument. Okay. And how do we know? Well, on June 27th of 2025, this is what was entered by the United States Supreme Court. It says these cases, because there's two of them that are traveling together, Robinson and Calais, these cases are restored to the calendar for re-argument. In due course, the court will issue an order scheduling argument and specify any additional questions to be addressed in supplemental briefing. It's interesting, right? So what ended up happening here? Well, in that order that was issued here on June 27th, 2025, I mean, I just read you something that seemed like it would only take up a couple of sentences, which it is, right? But then the rest of this is what? Clarence Thomas. Because Clarence Thomas always wants to assert his position just in case you weren't paying attention. Please. Well, let's talk about Thomas's dissent here before we get back to the scheduling order in Calais. Because Thomas, unfortunately, in my opinion, is signposting bad news for Section 2 of the Voting Rights Act. So Thomas says that he dissented from the decision to set these consolidated cases for re-argument later on in 2025. He says, I don't see any reason to avoid deciding these cases now. And I'm actually going to skip to the end of his dissent because it kind of sets the table for what he's seeking to do here. He states, for over 3 decades, I have called for a systematic reassessment of our interpretation of Section 2. The court's decision in Milligan is the latest and most damaging installment in the disastrous misadventure of this court's voting rights jurisprudence. So you may ask, what is Milligan? What is he referring to? He's referring to the decision of Allen versus Milligan, which was reached by this United States Supreme Court in 2023. In Milligan, the United States Supreme Court stated that the use of Section 2 of the Voting Rights Act to achieve a proportional allocation of political power according to race through the creation of a second majority Black congressional district in Alabama was okay. So Milligan is cited to as an example of Section 2 of the Voting Rights Act in a state like Alabama, a red state like Alabama, that Section 2 of the VRA allowed for, and even Thomas uses the word blessed, but he uses it in derision, but that the Section 2 of the VRA blessed that second majority Black congressional district being created in Alabama. So if you stop and you think about it, you have the United States Supreme Court itself stating that in the Milligan case, it is okay under Section 2 of the VRA to have a congressional district created for the purposes of complying with Section 2 of the VRA. But Thomas makes it clear in his dissent that he thinks Milligan is a disastrous misadventure. And he said, quote, I am hopeful that this court will soon realize that the conflict its Section 2 jurisprudence has sown with the United States Constitution is too severe to ignore. He wants, as in Thomas wants, to call for the complete destruction of Section 2 of the VRA. According to Thomas, he claims that the new congressional districts that have been created post Robinson versus Ardoin and in this Calais lawsuit, right? He claims that those districts violate the law because those are racial gerrymandered districts. And he says now that the Supreme Court has put the cases, like Milligan and other those cases, have put the Supreme Court to a choice. It, as in the court, may permit patent racial gerrymandering under the auspices of Section 2 compliance, or it may admit that, as the court has construed the statute, a violation of Section 2 is insufficient to justify a race-based remedy. That decision should be straightforward. Nevertheless, the court demurs, as in the court doesn't want to reach that decision now. So let's talk about the order that was entered on August 1st, which is here, which was the scheduling order that I mentioned to you. On August 1st, the Supreme Court stated that supplemental briefs are going to be filed. And these briefs have to address the following very important voting rights question. Quote, whether the state, as in Louisiana's, intentional creation of a second majority minority congressional district violates the 14th or 15th Amendments to the United States Constitution, the equal protection, like the due process ideas, right? Supplemental briefs are due by August 27th by the appellants. The appellees file their briefs by September 17th. Reply briefs are due Friday, October 3rd. And then oral argument's been scheduled for October 15th. And that was not in the order, but I found that out today. October 15th, 2025 is going to be oral arguments in the Robinson and Calais cases. This is heavy stuff, people, and I'm glad you're sticking with me up until now. The reason why I'm kind of meticulously walking you through what's happening here is I want to remind you that Congress, in its wisdom, passed the Voting Rights Act specifically for the purpose of providing these protections so that we didn't have just kind of what we're going to see happening in Texas and what we're seeing in Florida and what we're seeing in other red states. The wholesale elimination of the voice through the voting process of communities of color. Shelby County, I mentioned a few minutes ago at the beginning of this video, if you recall that Shelby County decision back in 2013, the Supreme Court struck down and said it was unconstitutional, one of the key pillars of the Voting Rights Act. That required jurisdictions that had a history of racial discrimination in voting, that those jurisdictions have to get federal approval before they make any changes in voting laws that would decrease minority voting power. When the United States Supreme Court struck down that provision of the Voting Rights Act in the Shelby County decision, it set up the Voting Rights Act to basically be a two-legged stool, if not a one-legged stool at this point. And the saving grace, the lifesaver that's been thrown to a lot of communities of color has always been the Section 2 of the Voting Rights Act. But now in this Calais decision, and again, this is something that has flown below the radar. I invite you to let me know, did you know about this? Did you know that this was happening? There was always so much going on that we kind of, I think, take for granted that our media is always going to let us know what's happening. And I would submit that mainstream media is not talking about this. They are not talking about this. You here at your channel, we're talking about this because it lives in tandem, symbiotically with what we're talking about in Texas with redistricting and gerrymandering that's happening there. All of these challenges eventually make their way into the space of the Voting Rights Act. Some of them make it as far as the United States Supreme Court. I mean, that's what we're talking about here, this Louisiana case, these Louisiana cases. And so I really want you to focus on this. I will continue to bring you updates on this. Because if Section 2 of the VRA, if it hits the guillotine in October, and if Clarence Thomas gets his way, I will say to you with no hyperbole, do not expect to see another congressional districting map that provides for Blacks, Browns, Asians, and other people of color to be able to have a chance at being able to vote their candidates into office. Because the way these maps are continued to be drawn, if there are no independent commissions like we have in California, if you rely upon your GOP Republican-led legislatures, we're never going to see a redistricting happening that is going to allow for communities of color to be able to have a candidate of their selection. And when you combine that with the other voter suppression methods and means that have been deployed by the Republicans and the GOP, and that have been fully marqueed in Project 2025 as being the intention of the Republican Party, we have some serious problems. Serious problems. Because you have to vote to affect the change that we need. You have to vote to be able to put people in control of levers of power, not only in DC, but in our local, state, municipal governments and in our courts. The Supreme Court justices are not appointed out of the ether. You need a president to do that. You need a Senate to confirm. And those need to be sound, wise, decent people, which right now is not the Republicans. But how do we do that? How do we vote when you have absolute and egregious dilutions of voting power that happens when things like the United States Supreme Court continue to decimate the Voting Rights Act? We're seeing it happen in real time. And that is why I wanted to carefully and thoughtfully walk you through this Calais issue and this Calais case, because it's being teed up. It's been teed up. And with the re-argument on whether or not the Section 2 of the VRA is going to allow this to happen, is going to protect those 2 congressional districts in Louisiana, this is going to be the test case of whether or not Section 2 of the Voting Rights Act continues to survive. Be mad, be outraged, demand accountability. I'll see you on the other side. Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.